So I'd like to introduce myself. I think a lot of you that are viewing this probably have viewed other webcasts we've done. I'm Ken Pope. We have a law firm. There's 7 of us. And we specialize in assisting families that have kids with disabilities and special needs. We do estate planning. We do legal guardianship. We do, thanks, Don. We do tax credit backfiling. We do ODSP applications. It's a combination of approximately 13 things. And it's developed organically since February 26th of '96. And we've just kept adding on services that clients needed. And as they needed things, we found ways to do them. And eventually it wound up to be a sort of a one-stop shop. So which is good. You know, you don't have to find, I don't know where you would find certain of the skills that we provide, but it's a good practice. Our firm motto is to do good and do well. And that's what we do the best that we can, to do good and do well. And of course, most of the doing good and the doing well part means that we've done good and done well for our clients. And then of course, we're cheerfully compensated for the results, which is always gratifying. You can see in the adjacent slides the parties involved. I trust that you can all see the display of the Q&A session with the team. Can everyone see that?
Yep.
Smiling pictures of all the parties and all the participants. I think that you may only be able to see my face right now interactively. I'm going to do a brief introduction. I have 200 people attending, so anything over that is bonus as far as I'm concerned. The next page, we have a 3-part slide here. Just to give you context, this is as of February 2020. These are the numbers of people that are on, people who are on ODSP. This doesn't include children under 18 who are not on ODSP, or that have turned 65 and now they're old age and guaranteed income supplement seniors. That would be approximately another third. But you can see here that there are 378,000 ODSP recipients in the province. And if you make a simple calculation, what you do is you take the total population at any given time. And what StatsCan says is you divide that number by 3, and this will give you the number of households. So you can see that there's approximately 4,566,000 households in Ontario, and not including all the children with special needs under 18 and the seniors over 65. There are 378,000 on ODSP. And as I say, that's approximately a third more, let's just say 100,000. So that's 478,000. So that's 1 in 10. So 10% of 4,566,000 is 456,000. So that would be 478,000. And that's 1 household in 10. Which is very interesting, I think, because a lot of times, you know, families are so busy, you know, that they think they're crazy and alone. And sometimes they are crazy, sometimes they are alone. But for the most part, they're not. It's just that they're so busy with their, you know, nose to the grindstone that they feel alone, and they feel a little bit crazy sometimes. We did a recent survey to ask people what the real cause of them delaying doing their wills and Henson Trust and so on was recently. And you get all the, we gave people all the regular boxes to tick: cost, time, expertise, locating a lawyer, getting to the office, you know, these kinds of things. And 46% said other. And then when you go into the other, the majority of them, what they were saying in different ways was that they're so busy taking care of their child that they just haven't had time. And we understand that, we acknowledge that. It's not uncommon at all, you know, to have a client family contact us 10 years later after I've done a seminar in Sudbury, say, and perhaps they even come to town. Not that many clients actually come to the office, but because the clientele are again proportionate to the province and our services to those clients across the province. If there's 1 million people in Ottawa and there's 13.7 million people in Ontario, then 1 in 13.7 might come to the office, possibly. But one of the advantages, especially now under this COVID situation, is that our work is almost always done remotely. So it's an easier delivery. If you live in Kapuskasing, you know, you're pretty tired of having to drive to Sudbury or Toronto to get services for things for your kid. So we're very pleased to be able to deliver those services remotely. But the context of this is important, I think. And I'll just go to the third slide here. This is the general breakdown of the types of special needs and disabilities of people in the province that are on ODSP. You may find this interesting. I don't know where, for example, autism would specifically go on this chart. It's not a developmental disability necessarily. It might be a cognitive disability, perhaps, or maybe not. But I'll have to talk to the statisticians and see where they would put that. And a lot of these, of course, are what are dual diagnosis. So what they do is they pick one of the disabilities, and then of course there's more than one often. So that said, I'd like to get started. I'm going to give the kickoff question and answer, and then Christiane, are you going to coordinate the questions as we proceed from there?
Yes. Yep.
Can you see the new entries, the new ones on the scroll here?
Yes, I can.
Okay, fine. Diane and I did a recorded radio show today, this afternoon. And if you want a copy of the radio show recording, let me know. It's a broadcast on Monday. And the question that I was answering was one that was sent in by a woman to comment on families with kids with special needs that unfortunately break up. And so my comment was that I think anecdotally, families with kids with special needs do break up slightly more than others, I think. That's been my perception. I know that under this COVID situation, there's a lot of talk by the family law bar about an increase in people coming to them, talking about divorce, talking about situations in the family. The last number I heard was about 150% increase. I don't know if that's true or not, but that's what I've heard. And the problem, of course, in a lot of families with related to ODSP is that special needs may not be limited to the child, could also relate to a parent. Because, of course, with mental health issues, perhaps it could be an inherited issue. Might well be with Asperger's that, you know, the focus and the drive that the father has manifests itself in the son. And you sitting there talking to the father, who happens to be an emergency worker, and you're doing an ODSP application, and you're listing the qualifications and why your son should get ODSP and what his unique characteristics are. And the father turns to the left to look at me and says, "That's me." So it's a very interesting practice. And in the case of a divorce, you often wind up with, for example, a couple, they have 3 children. After each child, the mother has postpartum depression. And then perhaps after the 3rd child, it doesn't lift. As a result, the family breaks up. The children stay with the father. He stays in the home with the children. He continues to work. Then one day she gets her share of the matrimonial assets, the house. But now she's going to receive an asset which will disqualify her from benefits. So we assist when we can in that kind of scenario. We typically can. And we often advise family law lawyers that in that kind of scenario, there's no sense trying to fight for spousal support because it'll simply be offset against ODSP. And we advise about child support, ways to make sure that that doesn't offset ODSP, and how to exempt the assets as a part of the division and so on. So it's some unique aspects to this as far as separation and divorce are concerned. So I'd like to give the floor over to the rest of the team now for a while. Who's got the first question that we'd like to answer on this?
I'm going to take the first one. It's coming from Nassar. He's asking, how can we claim the DTC when we don't pay tax? And that's unfortunately a common issue, and it's too bad the way they've set it up, but the disability tax credit works against taxes paid. And so if you're not earning any taxable income, the credit's essentially useless, aside from the fact that you can open up an RDSP account, which is great, but you can transfer this credit to a family member that is supporting you in some way with food, clothing, or shelter. So that's a solution. Let me see. The next question is for Crystal. It's coming from Candace. She says, ODSP and benefits changed when my sister turned 65. What benefits is she entitled to as a senior?
Who's that been assigned to?
That's for Crystal.
Okay.
Sorry, I was just trying to figure out how to get myself off mute. So the answer is old age security, guaranteed income support, and CPP, sometimes with disability and sometimes with not. It's a higher test. And you can find these applications easily online or through your Service Canada My Account. You can apply there too. There are certain criteria that need to be met. So you'd have to check online to see if you meet the criteria to apply online.
I'd like to jump in for a sec too. One of the big questions I get, because more and more people are turning 65, is you know, they're afraid they'll be even more impoverished by OAS GIS. The combined old age security and GIS is about $18,000 compared to the total of ODSP, which is presently about 14. And the other services, drug coverage and so on, they're all available to seniors like myself and every other senior. So there's no charge for Ontario Drug Benefit Program once you turn 65. So it's in some ways an improvement.
Also too, they've just added dental.
Is that right?
Yes, so there's dental and drugs coverage after 65.
Excellent.
The next question is going to be for Diane. This is coming from NR. They ask, in regards to legal guardianship, is it necessary to get one for a child with disability before they turn 18?
Hi, Anar. And so the answer is no. It's not necessary to get legal guardianship because you have the ability to make decisions for them while they're a minor. And we can only submit the guardianship application when your child does turn 18. However, we should definitely have a discussion about guardianship when your child is 17, so come talk to me. And then we're going to just discuss what you can expect when your child does turn 18, and you know, any changes that may happen with your ability to make decisions for them when they turn 18. So for example, you might not have access to their medical records, and you might not be able to do even small things like book an appointment for them because now they're technically considered an adult.
Right. The next question is for Jennifer. This is from Betty. She asks, my will with a Henson Trust was set up when my daughter was a minor. Do I need to revise my will now that she's an adult?
Hello, Betty. Thank you for coming out tonight. I'm pleased to answer your question. Basically, can everyone hear me?
Yep.
Okay, perfect. It really does depend on the circumstances. Like, for example, do the executors of the will and the trustees of the Henson Trust do they need to be changed or updated, or deleted due to familial circumstances that have changed? For example, a brother may be the Henson Trust trustee. However, due to a fallout, he may not be the best option for it. So yes, your will would be you should probably look at updating your will if any of these circumstances change. Like, for example, or if you left a specific gift or a specific bequest to somebody who either passed away or you wish to change it or delete it completely, yes, an update of your will should be something that should be on your mind. And finally, does the estate distribution need to be updated? One of the things is like, for example, if you had 2 children, one child with disabilities, and the original distribution being 50-50, you may want to change it to 60-40 or 70-30, depending on the needs of the disabled child throughout their life. But any other any circumstances that have changed in your life, it should also be reflected in the wishes of your will as well.
Next question is for Rafika. This is coming from Julie. She's asking, what are some things to be aware of when setting up a Henson Trust? And how do we assess ODSP and the Disability Tax Credit?
Hi, Julie. Thank you for your question. So I guess what you meant by your question, how to assess ODSP, if you were referring to whether what goes into Henson Trust and whether it can affect ODSP or not, the answer is that you can deposit, you can have an unlimited amount in the Henson Trust without affecting your ODSP payments. You would have to eventually disclose that in due course after the trust has been set up. With regards to withdrawals, you can withdraw also an unlimited amount if it relates to disability-related purchases. So for example, if you want to get a wheelchair or if you want to hire someone who can assist with taking care of you, or for the person who is on disability, receive disability payments. On top of that, you can withdraw $10,000 out of the Henson Trust for any other purpose. With the part of the question that deals with the disability tax credits, I'm sure my colleagues, Crystal, Terrace, will be able to add more details, and Christiane as well. But basically, the short answer to that question is this credit is available for individuals who have a severe and prolonged impairment in physical and mental function. So prolonged would qualify if it lasts at least 12 months. To check if you ever claimed that credit or not, you should look into your tax return on line 318. So that's where you will be able to see. If you haven't claimed it before, we can definitely talk about that and assist you with it. There is a lot of times an option available for people who qualify for it to backfile it 10 years back and recapture a significant amount of tax credits. There's also another tax credit available, and it's called Caregiver Tax Credit. It is also available for backfiling retroactively back to 10 years. You can recapture from 7,000 to 10,000 in tax credits. And to check if you ever applied for it, you should look into line 307 in your tax returns. Now let's go to the part of the question that deals with Henson Trust and what to be aware of when you're setting it up. So there are a number of factors that you need to be aware of. And we actually have a retainer with a list of things that we do for our clients when we're setting up the Henson Trust. But some of them that you need to consider is you first of all have to review the testamentary document, or in other words, a will, if Henson Trust was provided for in a will. You have to review the terms of the document, because that will affect, the wording is key in establishing a Henson Trust that will not fail, right? Another thing you need to consider is investment strategies, and this is something that we also discuss with our clients. We also suggest and recommend that they contact qualified investment professionals who specialize in investments. Another thing you need to consider is, let me see, how can you withdraw funds from the trust, for example, without affecting your ODSP payments, right? Because the amount will also depend on how much you can withdraw and whether it will affect it or not. So you need to be cognizant of that when, when you're thinking of withdrawing money from it. Another important thing is tax filing, tax returns for the beneficiary as well. Whether you can attribute income of the trust to the beneficiary in order to reduce taxes and how this can be done. When we talk with our clients, what we often do is we discuss and explain paid versus payable rule, preferred beneficiary elections, the use of the qualified disability trust. These are some of the factors that you need to be aware of when you're setting the trust up. And we would be happy to go over these factors and provide you with further information.
Cool. Question, I feel like it's sort of branching off of that. I'll give this one to Ken. It just came in from Nirmoli. They're asking, the ODSP website mentions a $10,000 limit on disbursements per year for Henson Trusts, but you say there's no limit. What's the confusion there?
Is this Nirmeli? If it is,
Yeah.
I'm glad to talk to her. This is a common confusion, of course. The individual on ODSP can only receive directly, if they were to receive it and manage it, up to $10,000 a year, per 12 months, $833 a month, for example. Not many families actually do give their children that much money. They might spend that much money for them. Say if they're in an apartment and they're paying $1,000 a month towards the rent. But those payments, while the parents are alive, are usually paid directly to the property manager and don't, in practice, don't have an effect on the child. But if you give and document, like a bank transfer, up to $10,000 or more over a 12-month period, then technically speaking, when it surpasses the $10,000, it offsets their ODSP to the extent that it surpasses at like $120, for example. But that's just the simple rule. And of course, the real guideline is not so much the parents while alive, because that doesn't seem to have much impact. Those gifts to the child or the payments to third parties, gifts are in cash usually, they're not traceable. But even if they were, you could then still do it the way the trust does when the parents are gone. And what you do is, for example, the child's living in an apartment, parents are paying $1,000 a month to subsidize the rent because the shelter component of ODSP is, let's say, $497. So you need $1,000 to subsidize them each month. Well, it's one thing for the parent while alive to give the property manager $1,000 or to co-sign the lease, in which event they can certainly pay the $1,000 of rent on their lease. But what the trust does is it might, for example, say, okay, the budget is an extra $1,000 a month per year. I'm going to prepay an annual amount of $12,000 or $24,000 or $36,000. And of course, the property managers are ecstatic, because what you do is you give them the $12,000 or the $24,000 or the $36,000 to prepay $1,000 per month for 1 or 2 or 3 years. And technically speaking, when you report this disbursement from the trust to ODSP on some kind of annual report, yes, it's true that it's a little different when the parents are gone. The trust has to disclose this. And in the month that you give the $12,000 or 24 or 36 to the property manager, it's deemed to be received by the child. And they are then overpaid for 1 month's worth of ODSP. And what ODSP does is puts on their monthly stub that they're overpaid $11.69, and it's going to be clawed back at the rate of 5% or roughly $50 a month until it's recovered. And that's all. And no matter how many times you do this overpayment for prepayment of the shelter costs, payment for a trip to Disneyland or Cuba, or whatever accumulated things you want to do to enhance the quality of life of this child. You can do them any number of times you want. You'd try to be reasonable and logical, obviously. But if you did it 3 times in a year, rather than using a bit of foresight and doing it once, you'd have an overpayment 3 times. So there'd be 3 times 1169. But the amount of the recapture would only be $50 a month. It would just take a much longer time to do it. And we've had overpayments of tens of thousands of dollars, and various circumstances can generate this kind of overpayment, for example, and it's still $50 a month. So it's really it's not that complicated. I'm done.
Okay. The next question I'll take, it's coming from Irene. She's asking, can I still claim the caregiver and disability tax credit if my son no longer lives with me? And the answer is yes. The disability tax credit has always been usable, whether or not you live at home. It's always based on the support of food, clothing, and shelter. And as of 2017, the caregiver credit followed suit, and now you no longer need to live with them as long as you're providing support with food, clothing, shelter. You're entitled to use both of these credits. Next question is for Crystal. This is coming from Carol. She wants to know, why does ODSP want to know if the recipient of ODSP has a life insurance policy, and what happens if he does?
Hi, Carol. They want to know the answer to that because it's considered part of your assets. Some life insurance policies have a cash surrender value, and the cash surrender value is considered an asset. And this used to be pretty important when the asset test was $5,000 at ODSP, but in 2017 they increased it to $40,000. And so now that part of it is not so big anymore, just because it's unlikely that your cash surrender value would surpass the 40,000 asset test. However, it is important to consider it when you're calculating assets. And that's basically why.
Thank you. Next question is going to go to Jennifer. This is coming from Alan. He's asking, what do you do when you have no one trustworthy or willing to manage your Henson Trust or estate?
Hello, Alan. Thank you for asking this question. It's the most common question that we do get when we do draft our wills, is that some clients don't have extended family members, or if they are in disagreement with other family members, then who do we go to sit there and have to be executor of the will and the trustee of the Henson Trust. Now, one of the suggestions, and I know my colleague Diane will definitely weigh in some of this as well, is that one of the suggestions that we would use is a trust company. A trust company can be an executor and a trustee of a Henson Trust, and you basically can settle your estate, ensure that the child's Henson Trust payments are paid out in a good manner. And also, with one of the benefits of having a trust company is that the trust company will be with the child throughout its life. And I believe that my colleague Diane can weigh in more about trust companies.
Yeah, we had a question actually for Diane that I was saving to go right after that one, which is, what are the advantages and disadvantages of having an institution versus a legal firm manage the trust?
And this question is from James. James, hi James. So, I can't speak to, the disadvantages or advantages of a legal firm managing a trust, because I personally have not dealt with any files like that. What I can speak to is about a trust company managing a trust. We have clients choose a trust company to be their executor, to manage the estate trust, or to manage, let's say, a Henson Trust. And there are several reasons why, a trust company does have vast experience with dealing with financial matters. The settlor or the testator can also be satisfied that the trustee will have a perpetual existence. So there's no worry about, a person, their friend, an individual dying, and then now there's an issue of who's going to replace that trustee. A trust company can also be unbiased and impartial. They don't have a long-term history or relationship with the beneficiary, most likely. And, a trust company, they can also remove the emotional burden that maybe, an individual who has just, still grieving might not have the means to deal with decisions about dispersing money to a beneficiary.
Yeah.
And also, what Jen said, sometimes the testator or the settler, they don't have anyone else, any friends or family that they can think of that they trust enough to manage the trust for their beneficiary.
Thank you. The next question is for Ken. Laura is asking, what can I do to be proactive in regards to my son's financial and housing provisions for when I'm no longer alive?
Well, what most families try to do is to come up with a suitable, safe, secure, affordable housing situation for the child. The child may stay with the family. About 47,000 people of the 370,000 are still with family. And of course, from when the child turns 18, they're typically with family. But most families try to make a transition at some point to have them in supported living or their own independent living with individualized supports, perhaps. Most families would try to make this transition when it's time, whenever that time is, certainly before the parents die, if at all possible. Otherwise, you're doing it in a crisis situation. Of course, if it is a crisis situation, the second that the parents has passed on, the child has been on a waiting list, so-called, for housing for 20 years. And of course, they're not going anywhere because they're safe and secure with mom still until mom dies. And then all of a sudden mom dies and it's a crisis. So then they get boosted up the list and get, initially a respite place. And then they eventually get some sort of placement. But the parents aren't around to have any input into that process. And, one would hope that there might be siblings involved, but not always, of course, right? So it's a very difficult situation. But that said, the plan for each child is different. Eventually, as you can see, if there's 370,000 people on ODSP and 47,000 at home, most of them do actually either live on their own or with supports. Let me show you those numbers for a second. You can see here that, here it is. You can see that 48,000 on this list are still at home with parents. They're boarders, room and board. 19,000 people on ODSP actually own a home. And this number, 293, are renters. So that's the majority, of course. And then there are also 17,000 other, whatever the heck that is. The subsidized is a small number. What doesn't pop out clearly to me is how many of these people would be considered living in supported living. So again, we'll have to see if we can get the statisticians for ODSP to tell us where's the number that are living in housing supported by community living, for example. How does that fit into this? Right, they're not owners, right? Are they renters? Are they considered renters? I don't know. But it's a very awkward situation, and it's a troubling situation for most families. When Diane and I did a recording of a radio show that's going to be broadcast on Monday, and part of what we discussed was the phenomenal technological strides that have taken place in the last 5 years, where parents can monitor remotely. Like there's a safety issues, there's security at home, there's personal health and safety, daily living skills, household and domestic skills, finance and budgeting. These are all things that need to be considered for the child's well-being, especially considering that only a proportion of these children are not competent. You might be able to say that perhaps half of the people with developmental disabilities are not competent, perhaps. How many of the kids who have mental health issues with neuroses and psychoses, how many are not competent? You know, so that you could have legal guardianship for them to handle their affairs. And as you can see, the number that are not at home is substantial. So there's been a transition for all of those kids. But it's an ongoing, continuous problem for all families, and you just have to work your way through it. It's a bit of a muddle. We have a category of file called advanced placement. Crystal handles that. And it's a matter of knowing the ropes and finding a way to have a child placed in advance rather than waiting till there's a crisis. But that's basically what it comes down to. You have to muddle your way through, connect with the right supporting organizations, perhaps have them in a day program, let them understand that your child's a great individual, easy to work with, because as an organization, they would like to have easy to work with people because it takes less expense for them. It's a business, right? It's a very interesting discussion, and I can't just give you an off-the-shelf answer. It depends on the child's needs, the community you're in, the alternatives you have. If you're in a small town like Russell, for example, inside of Ottawa, what are your options there? Right? So I don't know if that's a proper answer to your question, but it's a concern for all the families.
The next question is for Rafiga. Joan is asking, what exactly is a Henson Trust, and can we go through our own lawyer to set it up?
That's a good question. So what was the name again?
Joan.
John. So thank you for your question, John. The short answer is yes, you can go through your own lawyer. The only thing you need to be aware of is that you want to go to a lawyer who specializes in this area of estate planning with Henson Trust in particular, because the wording in a will is very important. The way you create a will is very important. So what exactly is Henson Trust? Well, it is a trust that is created by parents' will in order to protect their child who is with disability and the recipient of Ontario Disability Support Program benefits, to protect those benefits. So basically, inheritance that is left to the disabled child does not affect disability benefits if they go to Henson Trust, which you create in your will. The name of this trust comes from a landmark case that was decided in 1989, and since then it is available and is used as an effective tool in estate planning. So as you may know, well, actually a lot of people don't know that, the recipients of Odsp, if there is no Henson Trust, the recipients of Odsp can only inherit up to $100,000. And there's a limited amount per year that they can withdraw. Usually it's $10,000 annually, or as Mr. Pope correctly pointed out, for every 12 months, $12,000, sorry, $10,000 for every 12 months. But this is not the case if you have a Henson Trust. So the solution for parents who have a child with disability is to have a Henson Trust created in their will. You can create it in a will, but there is also an option to create it while parents are alive. Although that's a different discussion, there are differences between a trust that is created when parents are alive versus a trust that was created after parents passed on. There are a number of differences, but the main differences that are worth pointing out is that when you create a Henson Trust in a will, and if there's a house that parents want to leave to a child with disabilities, that house can qualify as a principal residence. So that can defer capital gain tax payments, right? Which a lot of times is a substantial sum of money. Another advantage is that you can change this trust into a qualified disability trust after the beneficiary or the person who received the inheritance turns 65. And instead of paying 50% in taxes, they pay the income that they receive from the trust pays only 22%. So these are the main sort of factors that you need to consider. I hope that answers your question, but I think what will help you understand what Henson Trust is an example. We had a client, a lovely lady, 50 years old. She inherited money from her parents, from her mother. And she didn't know, 5 years before she reached out to us, she contacted ODSP after she got her inheritance, and she disclosed that to the ODSP. So instead of telling her what she can do to keep the inheritance and at the same time continue receiving her disability benefits, they cut her off. So time went by, time continued to go, and she depleted her inheritance, reducing it to $15,000. At that point, she reached out to us. She found out what can be done. She contacted the ODSP office, and they told her that, well, you didn't do it then, and now it's too late. This was obviously incorrect, and we fixed this problem in a matter of 10 days. But unfortunately, of course, while we were able to reinstate her benefits from the ODSP office, the money that she spent throughout these past years, well, those money were gone, basically. So that's why it's very important to consult with a qualified professional to get things right from the outset. But I hope this clarifies and provides you with an answer that you were looking for.
Thanks, Rafika. I'm going to take the next one. It's coming from Durrell. They're asking, I have had a T2201 for my son since he was 4. He just turned 18 and is approved for ODSP. Do I need to get a new T2201 for him? It's hard to say. Some people are approved indefinitely and some people are approved for a specific set of time, and then you need to reapply. Your cue would be if you've received something from CRA. But yeah, that's the best answer I can come up with. Not necessarily, but if you receive a letter from CRA saying that he needs to reapply, then yes. The next question is for Crystal. It's coming from Catherine. She's asking, what are the pros and cons of a lump sum withdrawal from ODSP at 65 to set up a trust fund?
Well, the thing with that question is that social benefits continue after the age of 65. Some of these programs are still income tested, so a trust fund might still benefit you in the long run. However, if you have a registered disability savings plan, the income that comes from those don't affect the social benefits. And you can actually take out money from your RDSP and use it for any reason. It doesn't have to be a disability related expense, but the fact that it comes from the RDSP protects your benefits. So I wouldn't take the money out of an RDSP and place it into a trust fund, because there's no $10,000 limit on an RDSP, whereas once you put it into a trust fund and you're still on social benefits that are income tested, there's still going to be rules that apply. Each program has its own rules, obviously, but from an RDSP, it's exempt as income and it's exempt as an asset. So I would not advise that.
The next question is for Jennifer, coming from Lisa. She wants to know, what's the benefit of having a Henson Trust instead of just setting up an RDSP?
Hi, Lisa. Thanks for your question. One of the benefits to have a Henson Trust for a disabled child is that it would protect the disabled child's inheritance, especially if the child is unable to manage their own money, or could possibly be easily taken advantage of. For example, it's an unlimited amount that goes into a Henson Trust. So, your estate can flow entirely until the Henson Trust, whereas with an RDSP, there is a contribution limit of $200,000. Let me see. Yes, the Henson Trust will also supplement the child's income throughout their life, whereas with an RDSP, and I imagine Crystal will definitely weigh in on my comments about the RDSP, is that an RDSP has to have at least a 10-year vesting period before the payments are made out at 59. Whereas with a Henson Trust, if the parents had passed away when the child is, say, 30, a Henson Trust payments can be made at 30 as opposed to 59, and also will not affect the child's ODSP benefits.
Thank you.
Thank you.
Next question's for Diane. This is coming from Paul. He's asking, how is legal guardianship obtained once the child reaches age of majority?
Hi, Paul. Thanks for your question. So there are different ways that a guardianship can be submitted and a guardian appointed. The way that I'm just going to explain how we do it at our office. It's through a process called summary disposition. And what that means, it's a guardianship application that is heard in writing. So there's no court appearance. Essentially what it is, it's a very large book, probably 120 pages to, less than 200 pages. And what it includes is evidence for the allegedly incapable person's ability to handle their personal care and their property. It includes affidavits of the applicants, the consents from the applicants, maybe consents from immediate family members, a draft judgment, and that whole thing is submitted to court. A copy is given to all the applicants. A copy is also given to the disabled person. A copy is also given to the public guardian and trustee's office. Now, so every single guardianship application has to be reviewed by the public guardian and trustee's office. The fee that they charge under the law, under legislation, is $250 plus HST, which is $250, I think, if my math is right. So in a nutshell, that's what the guardianship application process is at our office. But, there are still other nuances and other forms that, I'd like to talk about in more detail if I had time. So just give me a call and then we can discuss this further. Hello. Sorry, I realized, was I on mute that whole time?
I could hear you.
Oh, okay. Sorry. I was on mute, sorry. The next question is for Rafiga. This question is coming from Sheila. She wants to know how to check her will to see if it has a Henson Trust already in it. She's not sure.
Sure. Hi, Sheila. Thank you for your question. A very important thing to understand is that the key to creating a Henson Trust, a true Henson Trust, is in the wording. Because poor drafting of a trust can result in it failing to meet the true intentions of the testator, or in other words, the person who wrote and signed the will. And without the proper wording, the trust can in fact fail. So the wording is very important. That's the main point I wanted to make sure that is clear. Key elements of a Henson Trust are the following. You want to make sure that you provide, or the person who's signing the will, the testator, provides for the absolute discretion of the trustees named to manage the Henson Trust, specifically the distribution of income and capital of the trust should be in the absolute, must be in the absolute discretion of the trustee for the benefit of the named beneficiary. So the child, or an adult child who's supposed to receive the inheritance. So another factor you need to consider, an important element of the Henson Trust, is that the language must also indicate that the trustees are not required to pay out to the beneficiary upon beneficiary's demand. So basically, the beneficiary doesn't have the authority to instruct the trustee to pay the money out to him or her. So this means that the trust is beyond, the trust funds are beyond the reach of the beneficiary. So that's the second point. The third important element is that the trust, what's called, does not vest with the beneficiary. So in other words, the beneficiary does not, never owns the trust. Unlike a normal or regular discretionary trust. With Henson Trust, it's an absolute discretionary trust, and it never, the beneficiary never owns the trust. It does not vest with the beneficiary. The trust funds or the assets are not beneficiaries' funds or assets, right? So these are the main important elements. The goal of this is that the beneficiary will simply receive payments or distributions made directly from the trust. But again, you would have to consult with the lawyer to make sure that when this is planned for and the distributions are made, if the trust has already been set up, it is done in a manner that does not affect provincial disability payments. So yeah, that's basically it.
Thank you. I'm going to take the next question. It's coming from Christine. She's asking or saying, we are in the process of reapplying for the DTC. When and if we're approved, is CRA going to credit us for past years that we didn't have it? And the answer is, you have to make sure when you get the doctor to complete the application, whenever your previous approval expired, for example, if it expired in 2015, when you get your new application approved, make sure it's either going back to 15 or even further backward on the date that the doctor puts down for when the restrictions started. So as long as that date is covering the years that it was expired and you didn't have it and weren't using it, then yes, you can get those past years. CRA will automatically give you the credit going back 3 years. If you need to go back further, you need to do the adjustments yourself or get somebody else to do it like us. Next question is for Crystal. This is coming from Clarence. The question is the government intending to provide financial aid to those receiving ODSP relative to the current pandemic?
Sorry about that. Hi, Clarence. Yes, the government just actually announced that there's going to be a one-time payment, made sometime in July. They haven't announced the exact date yet, but it's going to be a one-time $600 payment. Also too, in April, everyone who receives GST, so if you filed your taxes in 2019, then you're receiving the GST tax credit. I guess it would have actually applied to 2018 now that I think about it. And that GST payment went up $300 for a single person and $600 for a family. So you would have seen an increase in April. You're going to see an increase in July. And then on top of that, anyone who lost work and made $5,000 in the last 12 months is also eligible for CERB. And usually unemployment benefits are deducted dollar for dollar from Odsp. But the government announced that they're going to be deducting the CERB payments as if you're working, which is a benefit because the first $200 will be exempt. And then after that, 50% would be deducted from your Odsp check. So basically, you'd see a $900 reduction in benefits. So you're going to be up month to month if you lost work, if you're used to having that extra income. And if you weren't working, then, like I said, it's the $600 in July that you should be looking out for.
Thank you. I'm gonna pick one for Diane. This one's coming from Rosalia. She's asking, I have custody of my disabled daughter. If I die, can I entrust someone else other than her father with the decision making?
Hi, Rosalia. Thank you for your question. That's a good question, and you're thinking ahead. So if you want to, you're thinking of who can take care of your daughter after you pass away, then this person should apply for guardianship alongside with you. So, sometimes I have clients who are elderly and they apply for guardianship, but they also get their oldest child to apply with them, because when a guardian passes away, the guardianship terminates. So in order to prevent, another guardianship application being brought forth by a sibling of the disabled child, they will just include that child, their oldest child, with their application in the first place.
Thank you. Next question for Jennifer. This is coming from Kevin. He's asking, how does a life insurance policy transition into a Henson Trust at the time of death?
Hi, Kevin. Thank you for your question.
We've been waiting for you, Kevin.
We're waiting for you to call our office, Kevin. Anyways, what happens is that life insurance will pass into a Henson Trust. So first of all, what you have to do is you have to actually have your will with a Henson Trust provision added in. And what happens is that upon death, or then the second step is that an office would do a beneficiary designation, which basically has specific wording that any life insurance proceeds of X policy will flow into the Henson Trust. So when it came time that when you've passed away and the executors are settling your estate, they would see that in time that this beneficiary designation would basically be your wish to flow any funds, life insurance funds, into the Henson Trust for your child.
Thanks, Jennifer. This next one is for Figa. May is asking, what is the cost of operating a Henson Trust?
Hi, May. Thank you for your question. Very reasonable question. Again, the cost and a number of other factors will depend on the wording of the trust document or the will. Usually, there are trustee fees that range from 1% to 1.5% per year. So these are sort of the main costs of operating it. There may be investment fees, but those would be usually everywhere in if you're in a bank and you have an investment account, normally there would be investment fees. But the main point is that 1 to 1.5% trustee fees. Those are basically the main costs associated with operating Henson Trust.
Thank you, Rafika.
Thank you.
The next one is for Crystal. This is coming from Diane. She's asking, ODSP amount is 1069, 100 less than the maximum amount. What do you think we're missing?
This is a classic.
Well, I would definitely advise you to get out the ODSP stub that is delivered monthly and check the shelter amount, because chances are they're not getting the maximum shelter amount. I would be willing to bet that it says $397 instead of $497. And in these cases, we usually advise parents to just simply write a letter to ODSP increasing their shelter amount if they're still living at home. Some people are in subsidized housing, and if they're in subsidized housing, then ODSP will only pay the shelter that they're asked to pay. So there's really no way to increase it if that's the case. But you should definitely also make sure that everyone has tenant insurance, and also too that any utility bills are included inside that shelter amount, just to make sure you're getting the full $497.
Good point. So we're approaching an hour. Let's do a few more questions, but some people are dropping off. So I just wanted to make a note and say that obviously we can't answer all of the questions. There's been over 200 that have come in live, and like about 400 that came in prior to this. So we definitely were seeing that people like this, so we'll probably do this again. But I'm going to send the replay, and I'll include a family details link if you want to discuss your situation further with us. So with that said, I'm going to go over to Diane. There's a question from Ron. He's asking, can a Henson Trust change to a regular trust after it's up and operating?
Hi, Ron. So a lot of people, we do actually get this question a lot. A lot of people confuse, a Henson Trust and think it's, not a regular trust. Really, what a Henson Trust is, usually it's a testamentary trust, meaning it's a trust flowing from someone's death. And there's two aspects to the Henson Trust, which we've already covered. One is that the capital and income cannot vest in the beneficiary, and the trustee of that Henson Trust has absolute and unfettered discretion. Let's talk about things you could change. You can change the trustee. If we're talking about a Henson Trust, the trustee could, if it was appropriate, decide whether or not they want to collapse the trust, but it would also depend on the factors, and it could mean that consents from the contingent beneficiaries might be needed.
Okay. Question for Jennifer. This is coming from Bev. She's asking, how do you do a will when your lawyer is telling you that your daughter or son is not competent to make decisions on who to leave their money to?
Hello, Bev. That's an excellent question, and then sometimes it's a question that we get quite a bit. Now, in order to determine competency of like a potential testator who may or may not be disabled, the person has to be assessed for capacity, and usually that's by their physician or another mental health professional, like such as a psychiatrist or psychologist. Now, the degree of competency in order to draft a will does depend on 4 factors. First of all, the first factor is that does the person understand what it means to make a will? Like, for example, if I were to draft a will, I would understand that I, Jen, give X person a Y gift, and I understand that I'm giving that away upon my passing. Now, a second thing you have to understand is that does the person understand the extent of his or her property? Do they understand that I have a bank account and a house and a car? And then, to the extent of the fact that they know that upon their death, those things will be given away to a person possibly named in a will. They also have to understand the relationships he or she have with those people who might be expected to inherit a portion of their estate. This, like, for example, this person has to understand, like, the person is my sister and or brother, and I am leaving them half of my estate each. And the person has to understand that concept, that when they pass away, they are leaving something to an individual. They also have to have the understanding of potential claims that other people may have upon their estate, upon who he or she is leaving out of the will. Like, for example, like an ex-spouse may have a spousal claim against a person's estate. What it comes down to in capacity, if the person has no capacity to understand any of these 4 things, then unfortunately they cannot draft a will, because they don't have the capacity to understand those four factors.
Thanks, Jennifer. Next question is for Rafiga. This is coming from Tara. She's asking, can a Henson Trust be used for more than one inheritance?
Well, that's the short answer to that is yes, it can, but it can get really complicated if that's what you want to do. I guess the best way to explain this, because again, it can get really complicated, is that I will provide you with an example, a fact scenario. So, for instance, say you have, in this fact scenario, you have a grandmother, let's call her Mary. Sorry, grandmother, no name. And you have a daughter, her name is Mary. You have, grandma also has a son, so his name is John. So grandma, her daughter, and her son. The daughter, Mary, has a child with disabilities. Let's name her Emily. And Emily's uncle, John, has a son. So let's say grandmother creates a Henson Trust in her will, dividing her estate in 3 equal shares. So one goes to Mary, her daughter. Another goes to Mary's daughter in Henson Trust, not to her directly, but to her Henson Trust. And the 3rd share goes to Emily's uncle, or Mary's brother. So assume that the grandmother appointed Mary, her daughter, and her son, John, as trustees of the trust. So that's fine, but what grandma here intended is that the money would go to the daughter, to the granddaughter in Henson Trust. But what if that granddaughter will later, as time goes by, have a child of her own? So you can see the dynamic here that plays out. So one solution to that would be that the daughter, if she's capable, or sorry, granddaughter, if she's capable, would create her own Henson Trust in her will, whereby she would leave her share in Henson Trust for her own child. Because if she won't do that, the funds that she received in inheritance from grandmother going to the granddaughter, if granddaughter predeceases, would pass to her uncle's child. So, and not to her own child. So again, it gets complicated, but this is the example that I can give you. I would be more than happy to explain it in further details to you if you'd like. Feel free to give us a call and talk about it. But short answer, yes, you can have it. And again, it gets complicated. So yeah.
For sure. Thanks, Rafika. Let's do one more. Diane, this is coming from Maria. She wants to know what can I do to become my son's substitute decision maker, although he cannot sign or provide verbal consent?
Hi, Maria. Thanks for the question. The short answer is, I would need to know more detail, but just on what you've given me that he can't sign or provide verbal consent, it looks like guardianship is your option right now to become his substitute decision maker.
Okay. Should we wrap it up? There's people there. Yeah, okay.
Well, this is good. We had, I think, 223 at the top side.
Yeah.
Of I think 476 that were registered. I've
Yes.
been beavering away here answering a lot of these questions. Are they visible to the audience?
No.
That's
No,
what
they're not.
So I've got this long scroll of questions that when you see me looking rather,
And I've answered about 150 of them. I can't get to all of them.
Yeah.
A lot of people I just asked to email me.
Yeah, we've answered quite a lot. There's 38 left, but I think we've done a pretty good job. And we will be doing follow-up sessions like this. It's obvious that there's lots of questions out there, and I'm happy to answer them this way, and to do follow-up discussions with people if necessary. But I think that's enough for this evening. It's 8:15 now. It's time for everybody else to go and relax, and for us to do the same. Thank you for everyone for taking part.
Thanks, guys.
Thanks.
Thank you. Have a good evening, everybody.
Bye.